Everyone's heard that the Supreme Court issued an emergency 6-3 ruling. What almost no one understands is how radically this single decision reshapes the way power works in America, starting immediately, not years from now. This wasn't just another technical legal dispute buried in court filings. This was a quiet but seismic shift that changes who can block federal action, who benefits from court rulings, and who gets left exposed depending on where they live. And the most unsettling part? Most Americans woke up the next morning governed by a different legal reality without realizing anything had changed. For decades, a powerful judicial tool shaped national policy behind the scenes, the nationwide injunction. When a federal judge believed a law or regulation was unlawful, they could freeze it everywhere, coast to coast, instantly. One judge, one ruling, 50 states affected. That mechanism became one of the most influential and controversial features of modern American governance. With this emergency 6-3 ruling, the Supreme Court didn't just limit that power, it fundamentally redefined it. Overnight, the rules of the game changed. The court declared that federal judges generally lack the authority to issue sweeping nationwide injunctions that bind the entire country when only specific parties are before them. Injunctions, the court argued, should be limited to the plaintiffs involved, or at most, the geographic jurisdiction of that court. What sounds like a technical clarification is, in reality, a restructuring of how federal law functions in practice. Because federal law is no longer guaranteed to operate uniformly across the country. Instead, we're entering an era where legality itself may depend on geography. Immediately after the ruling, confusion rippled through the federal judiciary. District court judges who had relied on nationwide injunctions for years suddenly found their most powerful enforcement tool stripped away or severely constrained. Some judges publicly accepted the ruling, others reacted with barely concealed frustration, and a few issued unusually sharp statements suggesting the Supreme Court was not merely clarifying the law, but reasserting dominance over lower courts in a way that felt unprecedented. Within hours, appellate judges were signaling discomfort. Within days, legal scholars were warning that the ruling could fracture the judicial system into competing zones of authority. And behind closed doors, judges began asking a question that would have been unthinkable just a few years ago. How far are we actually required to go in following this? That question matters because this ruling does not operate in a vacuum. It collides directly with the reality of modern governance, where courts have become the primary battleground for policy disputes Congress refuses or is unable to resolve. When Congress passes vague laws and punts hard decisions to agencies, courts inevitably step in. Nationwide injunctions became a way to impose order, consistency, and predictability. Now that consistency is gone, and the consequences cascade fast. The first shockwave hit state attorneys general. Almost immediately, Republican and Democratic AGs began treating the ruling not as a legal clarification, but as a strategic weapon. Instead of filing one major lawsuit to block or defend a federal policy nationwide, states are now filing multiple lawsuits in carefully chosen jurisdictions. This is not accidental. It's calculated. By filing in multiple friendly districts at once, states can recreate the effect of nationwide injunctions through sheer volume. 10 districts issuing limited injunctions can still cover enormous portions of the country. The difference is cost, complexity, and chaos. Some states are even coordinating litigation across regions, forming informal legal alliances designed to overwhelm federal agencies with overlapping court orders. What used to be one clean legal battle is now becoming dozens of fragmented fights, each with slightly different rules and outcomes. And that fragmentation doesn't just affect politicians or lawyers, it affects ordinary people almost immediately. Because federal agencies are now operating in a legal patchwork. Take immigration enforcement. After the ruling, internal guidance circulated within federal agencies explaining that enforcement could proceed anywhere not specifically blocked by a court order. That means the same federal law may be enforced aggressively in one state, cautiously in another, and not at all in a third, based purely on which injunctions apply where. Environmental regulations face the same reality. Climate rules may be frozen in one circuit, partially enforced in another, and fully operational somewhere else. Workplace protections, consumer safety standards, healthcare regulations, everything now exists on a sliding scale of legality. This raises a disturbing question. If federal agencies enforce law selectively based on judicial geography, who is actually setting national policy? Congress or judges? That question becomes even more troubling when you consider Congress's role in all of this, or more accurately, Congress's absence. Rather than forcing lawmakers to clarify the laws they passed, this ruling gives Congress a convenient escape hatch. When constituents complain about inconsistent enforcement or unequal protections, lawmakers can shrug and point to the courts. Judicial chaos becomes political cover. Privately, many members of Congress are relieved. Tough votes can be avoided, controversial compromises can be postponed indefinitely. Litigation replaces legislation, geography replaces accountability. And while Congress stalls, powerful interest groups rush in. Advocacy organizations across the political spectrum are already raising massive litigation funds designed for this new environment. Instead of one carefully chosen case, they plan to file dozens. Legal strategy now revolves around identifying the most favorable judges, the most sympathetic circuits, and the most advantageous procedural rules. This is not justice by principle, it's justice by resources. Well-funded organizations can afford to fight everywhere. Grassroots groups cannot. Individual plaintiffs often can't even afford to fight once. The legal system is quietly shifting toward a model where constitutional rights are easiest to protect if your cause aligns with a wealthy sponsor willing to litigate across the country. And this is only the beginning. Corporations, election officials, civil rights organizations, and federal agencies are all adapting in real time. Business decisions are being reevaluated. Enforcement strategies are being rewritten. Election rules are being questioned. Entire professions are reorganizing around this new legal reality. What the Supreme Court did with this emergency ruling was not simply resolve a dispute. It set off a chain reaction that touches nearly every aspect of American life. And most people still think this was just another court case. In the next section, we'll look at how this ruling is already transforming corporate behavior, election law, and civil rights enforcement, and why the long-term consequences could define the next generation of American democracy. If the first shockwave of this ruling hit courts and state governments, the second is now tearing through corporate America, election systems, and civil rights enforcement, and the speed of the adaptation is staggering. Major corporations understood the implications almost immediately. For years, businesses complained that nationwide injunctions created uncertainty. One judge in one district could halt an entire regulatory framework overnight. But now, paradoxically, the same companies are discovering that a fractured legal system is far easier to manipulate than a uniform one. Welcome to the era of regulatory geography. Companies are no longer asking, what does federal law require? They're asking, where does federal law apply? Pharmaceutical firms are already evaluating where to locate research, manufacturing, and distribution based on which federal drug regulations are blocked in which jurisdictions. If an FDA rule is enjoined in one circuit but enforceable in another, corporations can restructure operations so the regulated activity technically occurs where enforcement is weakest. Tech companies are doing the same with data privacy, AI oversight, and platform regulations. Financial institutions are mapping banking rules against the injunction landscape to decide where different business units should be headquartered. Environmental compliance strategies are being rewritten to exploit gaps between circuits. This is not speculation, it's happening now. What makes this especially dangerous is that only the largest players can afford this kind of legal optimization. Small and mid-sized businesses don't have teams of lawyers tracking injunctions across dozens of districts. They follow the rules as best they can and end up at a competitive disadvantage compared to corporate giants who can shop for favorable jurisdictions. Economic development offices in certain states have noticed. Some are quietly marketing their regions not just for tax incentives or labor costs, but for regulatory stability, which increasingly means favorable injunction patterns. In plain terms, locate here and certain federal rules won't apply to you. At that point, the question becomes unavoidable. If businesses can effectively choose which federal laws bind them simply by relocating, is that federalism, or is that regulatory arbitrage masquerading as constitutional principle? Nowhere is this fragmentation more alarming than in elections. The Supreme Court's ruling didn't directly address voting rights or election law. But its implications hit election administration like a delayed detonation. Federal election laws covering voter registration, ballot access, early voting, mail-in procedures, ID requirements have long been enforced through broad injunctions when courts found violations. Those injunctions often ensured that rules were applied consistently within states, or even nationally during election cycles. That consistency is now at risk. Secretaries of state and local election officials are facing conflicting guidance. A federal election rule might be blocked in one district, but fully enforceable in another, sometimes within the same state. County officials are left guessing which rules apply to which voters. Imagine two voters living a few miles apart, governed by different federal election standards because of the district lines that separate them. Both parties see the strategic implications instantly. Legal teams are preparing to file targeted lawsuits in swing districts, knowing that even limited injunctions can shape turnout, ballot access, and vote counting rules in just the places that matter most. The goal is no longer to win a national ruling. The goal is to carve out favorable pockets of legal terrain. This sets the stage for chaos. The nightmare scenario isn't just voter confusion, it's election night disputes where outcomes hinge on whether certain rules were properly applied in specific districts. It's post-election litigation, arguing that results are invalid because voting procedures varied improperly within the same state. Election warriors are already warning that the 2026 and 2028 cycles could be the most legally contested in modern history, not because of fraud, but because of injunction geography. And if elections are the visible crisis, civil rights enforcement may be the quiet tragedy. For decades, nationwide injunctions served as a crucial tool for protecting marginalized communities. When courts blocked discriminatory laws or policies, those protections often applied broadly, ensuring that civil rights did not depend on zip code. That safeguard is now weakened. LGBTQ+ rights organizations are grappling with the possibility that protections they fought for may only apply in certain circuits. Disability rights advocates are confronting a future where ADA enforcement varies by region. Racial justice groups are warning that voting rights, housing protections, and employment discrimination cases may now require repetitive litigation in every jurisdiction where violations occur. Instead of one decisive ruling, it's dozens of battles with no guarantee of consistent outcomes. The practical effect is devastating. Organizations must choose where to fight and where to concede. Communities in hostile jurisdictions may simply be left unprotected because the resources required to litigate everywhere don't exist. The promise of equal protection under federal law begins to fracture. Civil rights attorneys are sounding the alarm. This ruling risks creating safe havens for discrimination, not because the law permits it, but because enforcement becomes too fragmented to sustain. And all of this is happening while federal agencies scramble to adapt. Inside agencies like the EPA, Department of Labor, DHS, and HHS, internal task forces are mapping where injunctions apply and where enforcement is legally safe. Inspectors are receiving guidance that differs by region. Policies are enforced aggressively in some places and cautiously or not at all in others. Career civil servants who once believed their job was to enforce laws uniformly nationwide are now being trained to navigate a legal maze. Their mission has changed. It's no longer about enforcing the law. It's about enforcing the law where allowed. That distinction matters, because when enforcement depends on judicial geography, judges are no longer just interpreting law, they're indirectly shaping policy outcomes. Which brings us back to the Supreme Court itself. Supporters of the ruling argue that this restores constitutional limits, reins in judicial overreach, and respects separation of powers. Critics argue it does the opposite, shifting enormous power into the hands of whoever can best manipulate the judicial system. Both sides agree on one thing: the system will never operate the same way again. This ruling doesn't just change legal doctrine, it changes incentives. It rewards fragmentation, forum shopping, and legal warfare over clarity, uniformity, and democratic accountability. And the longer Congress avoids stepping in, the more entrenched this new reality becomes. In the final section, we'll zoom out and examine the long-term constitutional trajectory this ruling sets in motion, and why historians may look back on this moment as the turning point when uniform federal law quietly gave way to a patchwork republic. To understand the full weight of this Supreme Court ruling, you have to step back and stop thinking in terms of court cases, legal doctrine, or partisan wins and losses. This decision is not about one policy, one president, or one election cycle. It's about the direction of the American constitutional system itself, and whether the idea of uniform federal law can survive in the modern era. For most of the 20th century, especially after the New Deal, the United States operated under an assumption that federal law meant the same thing everywhere. States could experiment at the margins, but baseline protections, regulations, and rights were supposed to apply regardless of geography. That principle was never perfect, but it was foundational. This ruling signals a break from that assumption. The Supreme Court is effectively endorsing a model where federal law exists in theory, but is applied in practice through a fragmented region-by-region system shaped by litigation outcomes rather than legislative clarity. In doing so, the court is reviving a form of neo-federalism that places enormous importance on judicial boundaries instead of national standards. Future law students may study this moment the way previous generations studied Brown v. Board of Education or Roe v. Wade, not because of the policy involved, but because of the structural transformation it represents. And like all structural shifts, the consequences will unfold slowly, unevenly, and often invisibly. One of the most profound changes is how power is redistributed. Congress loses authority not formally but functionally. When lawmakers refuse to pass clear statutes, enforcement shifts to agencies. When agencies are constrained by fragmented injunctions, power flows to courts. And when courts are constrained by geography, power flows to those who can best navigate the system: well-funded litigants, corporations, and organized political actors. Democracy becomes indirect. Voters elect representatives, but policy outcomes increasingly depend on which judges hear which cases in which districts. The distance between public will and legal reality grows wider. This also changes how the Supreme Court itself is perceived. Emergency rulings, once rare, are becoming more frequent and more consequential. Decisions made without full briefing or oral argument now reshape national policy overnight. That fuels skepticism, mistrust, and the sense that the constitutional change is happening without public consent. Lower courts feel it too. District judges, once empowered to act as national brakes on unlawful policies, now find themselves constrained and, in some cases, resentful. Some will comply faithfully, others will test the boundaries. Creative workarounds will emerge. Coordinated injunction strategies will evolve. The system will strain as actors push against new limits. That tension isn't accidental. It's the natural result of a judiciary trying to govern in the absence of legislative leadership. Meanwhile, Americans experience the effects in ways that feel arbitrary. A worker protected by federal labor rules in one state may lose those protections by crossing a border. A patient may have access to healthcare protections in one circuit, but not another. A voter's rights may depend on which side of a district line they live on. These aren't theoretical harms, they're lived realities. And when people experience law as inconsistent, trust erodes, faith in institutions weakens. The idea that the system is fair, already fragile, takes another hit. Supporters of the ruling argue that this discomfort is the price of constitutional fidelity, that nationwide injunctions were a judicial invention with no clear historical basis, that restraining them restores balance and prevents a single judge from imposing policy nationwide. There's truth in that argument, but there's also a cost, and that cost is coherence. A system that values limits over uniformity must grapple with inequality. A system that prizes judicial restraint must confront legislative paralysis. The court can restrict one tool, but it cannot force Congress to govern. Until Congress acts by writing clearer laws, defining remedies explicitly, and reclaiming its role, the courts will remain the battlefield, and battles rarely produce stability. Looking ahead, the pressure will only intensify. Election disputes, civil rights cases, environmental challenges, and regulatory fights will flood the courts. Emergency rulings will become more common. Fragmentation will deepen. At some point, something will break. Either Congress will be forced to intervene, restoring uniformity through statute, or the patchwork will become normalized, and Americans will accept that rights and regulations depend on geography. If that happens, the United States won't collapse, but it will change in ways that are hard to reverse. Federalism will no longer mean shared governance, it will mean shared uncertainty. This Supreme Court ruling is not the end of a story. It's the beginning of a long constitutional chapter whose outcome is still unwritten. The choices made now by lawmakers, judges, advocates, and voters will determine whether this moment becomes a course correction or a turning point. And that's why this decision matters, not because of who won or lost a case, but because it quietly changed how power works in America, overnight. If you want to understand where the country is heading next, this is the ruling you need to watch.